Okay, picture this. It's June 2017, Supreme Court of New South Wales. You've got this quiet little conference room just outside a busy courtroom.
Right. Mundane setting.
Totally mundane. And inside, there's a young solicitor, we have to call her MZEX. Her identity's protected by a court order. She's alone, door closed, on the phone.
And probably feeling the pressure, right?
Exactly. The hearing she was just in, it didn't go smoothly. The registrar apparently wasn't happy about some delays, so she's been sent out, to get urgent instructions from her boss, her supervising solicitor.
So she's stressed, just trying to sort things out. Standard day in court, almost.
Almost, because in that quiet room, in that very normal, everyday kind of legal setting, something happens, something that spirals. It turns into this really significant professional conduct case, a case that honestly sent ripples through the legal community in NSW.
And that's exactly what we're diving into today. We're pulling apart the case of the Council of the New South Wales Bar Association v. Raphael. And look, this isn't just some dry legal ruling. It's a story. It's about power, professional lines, and, well, what happens when those lines get crossed? Even when the person crossing them says, they meant well, or they were just being chivalrous.
Chivalrous, yeah, that word is definitely going to come up again. This whole thing, it really is a cautionary tale. And it's especially important if you're, working in law or maybe even thinking about heading into the profession.
Absolutely vital. And we've got the source material right here, mainly the detailed judgment from NCIT, that's the NSW Civil and Administrative Tribunal, plus accounts that sort of track how this whole case unfolded through the disciplinary system.
So our mission for this deep dive, we're going step by step through this specific case. We want to understand who was involved, what happened from that moment in the conference room right through to the tribunal's final decision.
Yeah, we'll look at the legal standards, the ethical rules they were talking about, the different arguments put forward, and really unpack why this matters. What are the big takeaways, especially for you listening, navigating your own legal career?
It's like a legal procedural, but wrapped up in this really crucial lesson about conduct.
Exactly. A cautionary tale laid bare.
Okay, let's start with the people involved, the dramatis personae, if you will, because understanding who they are and their positions relative to each other is just fundamental here.
Couldn't agree more. So, central figure, the respondent in the disciplinary proceedings, is David Keith Louis Raphael. Now, the sources tell us, at the time of this incident, back in June 2017, he was 78 years old.
78, okay.
Yeah, and his career, first admitted as a lawyer way back in 1965, and he'd been practicing specifically as a barrister since 1995. So decades of experience at the bar, a very senior figure.
A veteran. And what did the sources say about him, personally? I know character references came up later.
They did. And they paint, well, a bit of a mixed picture, maybe. Some described him as eccentric, old-fashioned, having an unusual sense of humor. Others said he was generous, kind.
Okay.
But then there's this recurring theme, a belief in acting chivalrously towards women. But critically, even some people providing those references acknowledged that his style of chivalry, let's call it, was seen by others as outdated or, frankly, even sexist.
That's a key tension right there. What he thought he was doing versus how it might land.
Precisely. And that tension is sort of at the heart of this whole case. Then on the other side of this interaction, you have M's ex, the junior solicitor.
Right, the one who was in the conference room.
Yes. The sources describe her as young, relatively inexperienced at the time. She was an employed solicitor working for a firm, and she was appearing in court opposite Mr. Raphael they'd never met before that day.
And her identity is protected.
It is. By a non-disclosure order from the tribunal itself, Section 64 of the NCK Act, which, really underscores the potential vulnerability in the power dynamic we're talking about.
Absolutely. You put those two people together, the 78-year-old highly experienced senior barrister and the young junior solicitor under pressure, meeting him for the first time. The power imbalance is just, immense.
It jumps right out at you. And that context colors everything that happened next. It's the backdrop.
Who else was involved in the story?
Well, you had Registrar Walton. He was the judicial registrar presiding over that directions hearing in the Supreme Court, sort of the court official managing that part of the case.
Okay.
And then the body that brought the disciplinary action, the applicant, was the Council of the New South Wales Bar Association. They're the ones responsible for setting and enforcing professional standards for barristers in NSW.
The regulators.
Exactly. And when the case got to the formal hearing stage, it was heard by a panel at NCKT, the tribunal. The sources named the members. Hennessy, ADCJ, that's a deputy president of the tribunal, P. Callahan, SC, a principal member and senior counsel, so a very senior lawyer himself, and E. Hayes, a general member. That was the panel making the decision.
And both sides had lawyers. Big guns.
Oh, yeah. This was taken very seriously. The Bar Association, as the applicant, had counsel P. Dwyer, and they were instructed by solicitors McCullough Robertson lawyers. For Mr. Raphael, the respondent, his counsel was C. Webster S.C., another senior counsel instructed by Carney's lawyers. Top-tier representation all around.
It shows the stakes. What about those character references? Any specific names mentioned?
Yeah, a few. People like Mr. Norman Gibson, who was a retired solicitor. He supported Raphael, but interestingly, the sources note he also mentioned Raphael sometimes made sexist jokes, or that friends had, chided him for inappropriate comments.
Wow, so even supportive references contain hints of this pattern.
Potentially, yeah.
There was also Miss McCauley, a former employee. She apparently observed that Raphael tended to only touch or use sort of terms of endearment like darling with female staff or colleagues, not males.
And others, too, like Mr. Strasser, Mr. Slater, Ms. Luca Leonard, Mr. Gelsky. Their statements were part of the material considered. But you see how even evidence intended to show good character could end up being complex. It fed into the narrative about his behavior being potentially problematic, even if long-standing.
It really paints a picture of all the different players, the individuals directly involved, the court, the regulator, the tribunal, the lawyers, even the character witnesses, all caught up in this examination of professional conduct.
It's a whole ecosystem, really.
Okay, so we know who's who, and we feel that power difference. Walk through what actually happened, the procedural summary. Starting with that directions hearing.
Right, so the context. Supreme Court directions hearing. Routine stuff, basically sorting out timetables for a case.
Yeah.
Mr. Raphael and Ms. X are on opposite sides. Never met before.
And she's already a bit behind the eight ball.
It seems that way. Her client had apparently missed some deadlines before, and the parties hadn't agreed on new orders. So when they get in front of Registrar Walton, he's not satisfied with her explanation for the delay. He tells her, essentially, go sort it out. Get proper instructions from your supervising solicitor.
Which is why she ends up in that conference room, alone, on the phone, under pressure.
Exactly. Trying to do what the registrar told her. Door closed. And then, the sources are clear on this, Mr. Raphael enters the room, uninvited.
He just walks in while she's on the phone.
Well, the source says he entered while she was in there alone trying to get instructions. Doesn't specify if she was mid-call at that second, but she was definitely in there for that purpose.
Yeah.
And he came in.
Okay. He's in the room. What does he say?
According to the agreed facts later presented to the tribunal, he makes a comment after noticing her wedding ring. Words to the effect of, won't your husband get jealous because we were spending so much time together? He will think something is going on.
Whoa. Okay. That's quite personal and unprofessional.
Yeah. Bringing her marital status into it with that sort of suggestive undertone. And the sources record Mrs. X's reaction to this. Her voice apparently became shaky. She became visibly upset. She actually started to cry. This is after that first comment.
So she's crying in this small room with this senior barrister she just met.
Yes. And it's while she is visibly upset and crying that he then makes physical contact. The sources describe him placing his arm on her shoulder.
Okay.
For somewhere between 10 and 20 seconds. And then he kissed the top of her head.
He kissed her head while she was crying after making that comment.
That's what the agreed facts state. Arm on shoulder, 10, 20 seconds, kiss on the top of the head. And after doing that, he apparently said something like, don't worry, you poor thing.
You poor thing. Wow. So the sequence is inappropriate comment. She gets upset and cries. Then he touches her and kisses her head while she's crying, then calls her poor thing.
That's the sequence presented to the tribunal, yes. The physical contact happened in the context of her distress, which itself followed his comment.
How did he perceive her reaction at the time? Did the sources mention his perspective?
Yes, there's a line in the source material that says, after several minutes, MSX seemed to the respondent to have recovered, and she ceased crying. So from his viewpoint, as recorded later, her visible distress lasted a few minutes before she composed herself.
Okay, and then they just went back into court.
After a few more minutes, yeah. They returned before Registrar Walton. The registrar made orders extending the timetable, and that was it for the court appearance that day. The immediate legal matter moved on.
But the incident in the conference room, that wasn't over.
Not by a long shot.
Yeah.
Because MSX didn't stay silent?
She made a complaint, which, as you said, for a junior lawyer against such a senior barrister, that's a huge step.
Massive.
Yeah.
Incredibly brave. And the complaint went to the council, the NSW Bar Association.
And they took it seriously.
Very seriously. They launched a formal investigation. And initially, this wasn't just about one minor rule. They formulated 5 separate disciplinary complaints against Mr. Raphael, all arising from that single interaction on June 5th, 2017.
5. What sort of things were they alleging?
The source suggests it covered different angles. Probably, the comments themselves as misconduct, the physical contact as separate misconduct, maybe broader things like workplace bullying under the rules or conduct likely to bring the profession into disrepute, Rule 8 breaches, that sort of thing. It showed they saw multiple potential violations of the professional standards.
So how did Mr. Raphael react when he got hit with these 5 complaints? This would have been a few months later, maybe September 2017.
That's right. His initial written response is really revealing, and it became crucial evidence later. He admitted the basic fact, the comments happened, the physical contact happened, arm on shoulder, kiss on head. He admitted that, but he massively downplayed it.
Right.
He denied it had the significance the Bar Council was giving it. He actually characterized his actions as, wait for it, attempted chivalry.
There's the word again, attempted chivalry.
Yep. Also called it a misguided attempt to console, a comforting gesture, even described it as familial. He argued these were just the innocent and innocuous practices of a long life, practices he felt were potentially admirable to many people.
Admirable. Kissing a distressed junior colleague you just met on the head is admirable. That's quite a take.
It shows a significant disconnect, right? And he specifically stated he did not consider at the time that there was the slightest sexual aspect to his actions. He just didn't see it that way.
And what about her reaction? Did he address the fact she was crying?
He did, but in a way that, raised eyebrows later. He stated that Memsex raised no objection at the time, nor would he have expected her to.
Nor would he have expected her to object. That line just leaps out. It speaks volumes about his perspective on the power dynamic, doesn't it?
It really does. The Bar Association's counsel later called this attitude willfully blind. He just didn't seem to grasp why a junior solicitor might not feel able to object to a 78-year-old SC in that situation.
Yeah.
As for the jealous husband comment, he brushed it off, called it flippant, a silly comment, just meant to lighten the mood, said it could not have been taken seriously coming from a 78-year-old grandfather.
So his initial stance was, facts admitted, but my intent was pure. It was harmless, maybe even admirable chivalry. She didn't object. You're reading too much into it, especially the comment. And he denied the comments alone were misconduct.
That was the essence of his initial defense, yeah. But then, as things progressed towards the actual tribunal hearing, there was a shift. The Bar Association decided to narrow the case.
How so?
They withdrew 4 of the 5 complaints. Complaints 1, 3, 4, and 5. They decided to proceed only on complaint 2.
And what was complaint 2 specifically about?
Complaint 2 alleged unsatisfactory professional conduct based specifically on the physical contact. The act of placing his arm on Miss X's shoulder and kissing the top of her head.
And he admitted that specific complaint.
Yes, that's a key procedural point. Mr. Raphael admitted that the physical contact, taken together with the context of the comments, did constitute unsatisfactory professional conduct.
Okay, so he conceded the physical touching crossed the line, professionally speaking?
He did. The Bar Association accepted that admission. So the focus for the tribunal hearing became less about whether misconduct occurred regarding the physical act, and more about the nature and seriousness of that admitted misconduct, the appropriate characterization of it, like harassment or bullying, and, crucially, the right penalty. The comments remained vital context, though, showing the overall interaction's unwelcome and sexual nature.
Got it. So admission made on the physical contact, the stage is set for the tribunal hearing.
Exactly. Off to NCAT, the NSW Civil and Administrative Tribunal Occupational Division. That's the venue for these kinds of professional discipline cases in NSW.
Okay, let's walk into that virtual or actual hearing room. December 2020. What happens?
The hearing date was 21st December 2020. You've got the panel, Hennessy, ADCJ, P. Callahan, SC, E. Hayes. You've got the legal teams, P. Dwyer for the Bar Association, instructed by McCall Robertson, and C. Webster, SC, for Mr. Raphael, instructed by Cornies.
And N's ex, was she there? Did she have to testify?
No. The sources are clear. M's ex did not participate in the hearing itself. The case proceeded based on the agreed statement of facts, which included Raphael's admission on complaint 2, plus other evidence like his initial letters and the character references. Her identity remained protected throughout.
So the hearing was essentially legal argument about the admitted conduct and what should happen because of it.
Precisely. It wasn't a whodunit. It was about classification, seriousness, and consequences.
How did Mr. Raphael's defense counsel, Mr. Webster, SC, argue his case? What was the pitch to the tribunal?
The core strategy was, essentially, mitigation and context. They framed the admitted physical contact as a clumsy, perhaps, but ultimately well-intentioned attempt to comfort someone he saw was upset. The big emphasis was on his intent, arguing there was absolutely no predatory or lewd motive, no sinister underpinning.
They stressed it was a one-off.
Yes, highlighted it as a single, isolated incident in an otherwise very long and, they argued, unblemished career. This is where those character references came in heavily.
Right, portraying him as kind, generous.
Exactly. Kind, generous, maybe a bit eccentric or old-fashioned, socially awkward perhaps, but fundamentally decent, not malicious. The jealous husband comment. That was painted as just his brand of humor, something friends knew, maybe inappropriate, but not insidious.
And the chivalry angle came up again.
Oh, yes. His counsel put forward this idea that he genuinely believed in being chivalrous towards women, even if it was an Edwardian concept, as one reference apparently put it. The argument was basically he was out of step, he didn't get modern norms, but his heart was in the right place.
So the defense picture is, well-meaning, older guy, made a mistake trying to comfort someone, didn't realize how it would land, feels bad about it now, embarrassed, learned his lesson.
That's the gist. And flowing from that, they argued for a lenient penalty. Specifically, they pushed for a caution, which is a private warning, doesn't get published widely, rather than a public reprimand.
And on the counseling point,
They suggested minimal intervention was needed, proposed just 1 hour of counseling, with the counselor then deciding if more was necessary, basically arguing he'd already learned his lesson through the process itself.
okay, that's a clear narrative from the defense. How did the Bar Association, through Mr. Dwyer, counter that? What was their argument?
Their approach was fundamentally different. They argued that Mr. Raphael's subjective intent, while maybe relevant to some degree for penalty, was not the main issue when determining if the conduct breached professional standards. The focus had to be on the objective nature of the conduct and its foreseeable impact.
So less about what did he mean to do, and more about what did he actually do and how would a reasonable person see it.
Exactly. And they put forward strong legal arguments for classifying his conduct. They argued it squarely met the definition of sexual harassment under Section 22A of the Anti-Discrimination Act.
How did they break that down?
They argued the physical contact, the arm on the shoulder, the kiss, was clearly an unwelcome act of physical intimacy. And when you combine that with the preceding comment about the jealous husband, the whole interaction amounted to conduct of a sexual nature. That's the first part of the definition.
And the second part, the reasonable person test.
They argued that test was clearly met. You have to consider all the circumstances. And here, the circumstances were critical. The huge power imbalance, senior SC versus junior solicitor, the age difference, the fact she was already distressed, the fact they were alone in a room. In those circumstances, they argued, a reasonable person absolutely would have anticipated that Mana's ex would be offended, humiliated, or intimidated by his actions.
Her actual reaction, the crying, wasn't legally necessary for that test, but it supported the argument.
Precisely. It showed the foreseeable impact actually occurred. But the legal test is objective.
Did they also argue it was workplace bullying?
Yes, they submitted it also fit the definition of workplace bullying under Rule 125 of the Barrister's Rules, which talks about unreasonable behavior that could reasonably be expected to intimidate, degrade, humiliate, and so on.
And the general conduct rules, like Rule 8?
That too. They argued it breached Rule 8 because it was otherwise discreditable to a barrister and likely to diminish public confidence in the profession. They basically said, this kind of behavior makes all lawyers look bad.
What about his lack of insight? Did the Bar Association use his initial response against him?
Oh, definitely. That was a major part of their counter-argument. They pointed to his initial letter calling it a comforting gesture, saying he didn't expect her to object, claiming he'd done this sort of thing his whole lifetime as proof of a profound lack of understanding. His counsel used the term willfully blind.
They argued he just didn't get it, or didn't want to get it.
Exactly. And they cleverly turned the character references partly against him, too. They pointed out that references mentioning his sexist remarks, or friends chiding him, or him only touching females this way. Well, that didn't paint a picture of an isolated mistake. It suggested a potential pattern of outdated, inappropriate behavior that he hadn't heeded warnings about.
Undermining the one-off incident defense.
Right. And they placed the whole thing in a broader context. They referenced comments by the Chief Justice about harassment, pushing people out of law, the impact of #MeToo, other high-profile cases, arguing that this conduct wasn't just about Mr. Raphael and Android X. It damaged the profession's efforts to be inclusive and safe, especially for women.
So, based on that objective analysis, the impact, the lack of insight, the broader context, what penalty did the Bar Association want?
They argued strongly for a public reprimand. They said a private caution just wasn't enough given the seriousness. A public reprimand was needed for deterrence, to uphold standards, maintain public confidence, fulfilling the protective aims of discipline. And they pushed hard for substantial mandatory education and counseling, arguing for at least 8 hours. Because, they said, his responses showed such a lack of insight, possibly stemming from habits of a lifetime, that significant intervention was needed to effect real change.
So the tribunal is left with these two starkly contrasting interpretations of the same admitted actions. Defense, clumsy comfort, good intent, learned lesson, needs minimal penalty. Prosecution, objective misconduct, sexual harassment, bullying, disreputable, shows lack of insight, pattern concerns, means public censure, and significant re-education.
That's the clash they had to resolve, weighing the evidence, the admissions, the arguments against the legal and ethical benchmarks.
Which brings us to the judgment itself. April 2021. What did the tribunal decide?
The formal reasons for decision came down on April 16, 2021. And the bottom line finding: Mr. Raphael was guilty of unsatisfactory professional conduct, as alleged in Complaint 2.
The one relating to the physical contact, which he'd admitted.
Correct. They noted the other complaints had been withdrawn and were formally dismissed, but on Complaint 2, the finding was guilty.
And how did they justify that finding? What was their reasoning?
Their reasoning, laid out in the judgment, closely followed the Bar Association's arguments on the objective standards. First, they confirmed the conduct happened in the course of practice. Then, critically, they agreed it met the definition of sexual harassment under the Anti-Discrimination Act, Section 22A.
So they accepted that legal classification.
They did. They found his actions constituted unwelcome conduct of a sexual nature. They pointed specifically to the physical contact, arm on shoulder, kiss on head, as an unsolicited act of physical intimacy. And crucially, they said that this physical act, combined with the preceding comment about the jealous husband, made the conduct of a sexual nature.
And the reasonable person test?
They found that test was met too. A reasonable person, having regard to all the circumstances, would have anticipated MZX being offended, humiliated, or intimidated.
Yeah.
And they explicitly highlighted the power imbalance, the age, experience, seniority difference as being absolutely central to that finding. They said that disparity was critical in concluding a reasonable person would foresee her negative reaction. While her actual distress reinforced it, the objective test, considering the power dynamic, was sufficient.
Did they also find it was workplace bullying and breached Rule 8?
Yes, on both counts. They agreed the conduct met the definition of workplace bullying under Rule 125 of the Barrister's Rules, unreasonable behavior, likely to intimidate, degrade, humiliate, etc. And they found it breached Rule 8. Even though it wasn't dishonest conduct, they ruled it was otherwise discreditable to a barrister and likely to diminish public confidence in the legal profession and justice system. They were clear. This damages the public's trust in lawyers.
Okay, so guilty finding firmly established on multiple grounds. What about the penalty? Did they go with the defense's requested caution or the Bar Association's reprimand?
So they rejected the call for a caution. The tribunal ordered that Mr. Raphael be formally reprimanded.
A public reprimand?
Yes. They spelled out that a reprimand is a public censure. It goes on the official register of disciplinary action. It's more serious than a private caution. They said the conduct was serious enough to warrant it, and that a public reprimand was necessary to achieve the protective purpose of discipline, signaling seriousness, deterring others, maintaining public confidence.
And the counseling? The 1 hour versus 8 hours debate.
The tribunal went with the Bar Association. They ordered Mr. Raphael to undergo education and counseling at his own expense for a minimum of 8 hours.
8 hours. Why so specific and why so much more than he proposed?
They were very direct about this. They basically said changing ingrained behaviors or attitudes is highly unlikely to occur following an hour or two. They felt 8 hours was the minimum needed to have a reasonable likelihood of achieving genuine change, especially considering what they termed the potential habits of a lifetime, indicated by his initial responses and the references.
That mandatory education component feels really significant. It's not just punishment, it's requiring him to learn and change.
It absolutely is. And the tribunal gave guidance. The Bar Council should ensure the provider had expertise in behavioral change, and that they should get the case materials, the judgment, his letters, so the sessions could be properly targeted. It showed a commitment to making the intervention meaningful, using powers under the uniform law.
Did the tribunal comment specifically on his insight or lack thereof?
They did. They expressed considerable concern about what they called his complete lack of understanding of his behavior, both when it happened and in his initial responses. They highlighted his comment about not expecting M's ex to object as particularly revealing of this failure to grasp the power dynamics. They noted he only belatedly acknowledged the unacceptable nature of his behavior, implying his remorse or understanding came very late in the piece, maybe only once facing formal discipline, rather than through earlier reflection or heeding warnings.
Was there a sort of key takeaway message from the tribunal in the judgment?
Yes, beyond the orders, they included a very powerful statement aimed at the whole profession, really. They said Mr. Raphael needs to understand that this kind of conduct is not perceived by the vast majority of women as being comforting, chivalrous, or even vaguely humorous.
Directly addressing his justifications.
Directly. And then they added this critical sentence. Sexual harassment of this kind has the potential to adversely affect a victim's mental health and to dissuade her from continuing a career in the law. That connects the individual act to the systemic problem of retaining women in the legal profession. It elevates the significance way beyond just one incident.
So the outcome, guilty, public reprimand, and a substantial mandatory education counseling order. Accountability, public statement, and required action for change.
That sums it up perfectly. Complaint 2 upheld, the others dismissed as withdrawn. Reprimand issued. 8 hours minimum of education counseling ordered at his cost. Cost of the proceedings to be sorted out later. He wasn't struck off or suspended, but that public reprimand is a permanent mark, and the training order imposed a real obligation.
And the story didn't just stop there, right? The judgment landing publicly caused quite a stir.
It really did. When the decision was published in April 2021, it got significant media attention, legal press, mainstream news. The headlines often grabbed onto the age difference, Mrs. X's distress, and inevitably that phrase, attempted chivalry.
That phrase just stuck, didn't it?
It really did. It seemed to capture the whole disconnect for many people. Reports focused on the tribunal finding it was sexual harassment and bullying, and the emphasis on the power imbalance became a key talking point.
And it fed into those broader conversations happening around #MeToo and harassment in professional environments.
Absolutely. The sources note it was frequently discussed in that context alongside other high-profile situations like the Hayden inquiry findings. It was seen as more evidence that these weren't isolated issues, but reflected deeper cultural problems within professions like law that needed addressing urgently.
How did the NSW Bar Association itself react publicly post-judgment?
They definitely leaned into it as a moment to reinforce their stance. Later in 2021, they launched a visible campaign, No Place for Sexual Harassment at the Bar. They explicitly linked this to upholding standards and ensuring a safe environment. And spurred on by cases like this, they brought in some pretty concrete changes. Appointing an independent sexual harassment officer. Implementing a new confidential reporting tool, trying to make it safer and easier for people to actually report incidents without fear of reprisal, and developing new mandatory education programs, including a specific training film focused on sexual harassment at the bar.
So using the case as a direct catalyst for policy and training reform, that's quite proactive.
It shows they saw it not just as disciplining one member, but as a signal that systemic change was needed. Those earlier comments from people like Chief Justice Bathurst worrying about harassment driving people out of the profession seemed even more pressing after this case became so public.
Okay, let's really boil this down now. For someone listening, maybe starting their legal career or thinking about the bar, what are the absolute core ethical lessons from the Raphael case? This is the real cautionary tale part.
This is it. Number 1, loud and clear. Intent versus impact. Your good intentions, not a defense. Seriously, the tribunal couldn't have been clearer. What matters is the objective nature of your conduct and how it would foreseeably impact a reasonable person in the circumstances, especially factoring in power dynamics. Thinking, I meant well, just doesn't cut it if your actions cross the line.
You have to think about how it lands, not just how you meant it. Need that awareness.
Exactly. Self-awareness, empathy, understanding current professional norms is basic respect. Second, the case provides a concrete example of what sexual harassment and workplace bullying look like in practice. Unsolicited physical contact, especially when combined with inappropriate, sexualized, or overly personal comments, can meet those legal definitions under the Anti-Discrimination Act and the professional rules. It's not some abstract concept. It's about specific behaviors.
And the power difference is not just background noise.
Absolutely fundamental. Lesson 3. The power imbalance is critical. The huge gap in seniority age experience between Raphael and Mebus X was central to the finding that his behavior was foreseeably intimidating or offensive. What might be merely awkward between equals can become harassment or bullying when hierarchy is involved. Senior people have a greater responsibility.
What about his claim she didn't object?
That leads to lesson 4. No objection does not equal consent or acceptance. The tribunal used his comment about her not objecting as evidence of his lack of understanding, not as a point in his favor. People in junior positions often feel they can't object. Silence is an agreement. The onus is on the person with power to ensure their conduct is appropriate.
And it wasn't just about the specific interaction, but the broader professional standing.
Yes, lesson 5. Rule 8 in reputation matter. Your conduct reflects on the entire profession. Actions deemed discreditable or likely to diminish public confidence breach core ethical duties even if they happen outside the courtroom proper. Maintaining public trust is part of the job.
The character references also offered a lesson, perhaps unintentionally.
Right. Lesson 6. Beware the pattern of behavior. Evidence suggesting inappropriate conduct isn't just a one-off mistake, but part of a longer pattern, even if revealed through supposedly positive references, can actually strengthen the case for disciplinary action and the need for intervention, like training. It undermines the isolated incident narrative.
And that training order itself is a lesson.
Absolutely. Lesson 7. Mandatory training signifies a shift. The tribunal ordering 8 hours of specific education wasn't just punitive. It showed a belief that genuine behavioral change was needed and could be mandated. It reflects a move towards requiring practitioners to actively learn and adapt, not just avoid future breaches.
And finally, this case is now officially part of how new lawyers are taught.
Yeah, lesson 8, it's now in the textbooks. The Raphael case is being used in legal ethics courses. It's a real-world example driving home all these points about boundaries, power, harassment, and consequences for future generations of lawyers.
So for anyone listening, especially those starting out, this case is a really stark, maybe uncomfortable, but necessary reminder.
It truly is. The ethical rules aren't abstract. They're real. They apply to how you interact with everyone: colleagues, opponents, clients, staff, in every professional setting. Conference rooms, chambers, corridors, everywhere. Your behavior, your choices, they have consequences. For you, for others, and for the profession's standing. And the standards are evolving. The profession is trying to get better at this.
The whole journey, really, from that single moment in the conference room, through the investigation, the defense arguments, the tribunal's findings, the penalty, the public reaction, it really does feel like a modern morality play for the legal profession.
It totally does. It's that collision point between old attitudes, the attempted chivalry, the expectation of deference, perhaps looking the other way, and the standards demanded today, which are about respect, equality, safety, and holding everyone accountable regardless of seniority.
So, the final thought for you listening, as you navigate your own career in this profession that is changing. What does this case, Counsel of the NSW Bar Association v. Raphael, really tell you? When conduct framed as chivalry is found to be sexual harassment and bullying, what benchmark does that set?
It tells you the standard is high. It tells you it's your responsibility to understand and meet that standard. It's about contributing to a culture where everyone feels safe and respected. The quiet rooms, the informal interactions, they matter just as much as the courtroom arguments.
So the question to leave you with is, what kind of lawyer and what kind of colleague, what kind of person will you choose to be in this profession knowing stories like this?